So we're going to talk about discrimination in terms of public accommodations. Now, public accommodations are basically public commons, and we think of commons in terms of this idea that comes from economics, that commons are these things that are available to everyone and cannot be subdivided in any sort of meaningful fashion. So beaches, parks, buses, courtrooms, restaurants, hotels, on and on. These are thought of as public commons, in that once you build a park, for example, that park is available to everyone and you can't subdivide that park in any sort of meaningful fashion. So in the wake of the decision in Brown, I mean, all of these places were clearly segregated before Brown. And it's not as though Brown desegregated these areas. These areas were still segregated, but slowly as the tide of public opinion began turning, these areas began to be slowly desegregated, but there was no legal reason for them to do so. That was until the passage of the Civil Rights Act of 1964. The way by which these cases were desegregated, or these areas were desegregated, was through the Interstate Commerce Clause. The Interstate Commerce Clause of the Constitution gives the authority to Congress to regulate commerce that is between two or more states. Now, interstate commerce has been, really since the late 1920s, interpreted fairly broadly. And we really see it begin to be interpreted with some significance when the court switches. So after that switch in time, so really the mid to late 1930s, we see the court begin to give Congress significant discretion in the area of interstate commerce, to the point that almost everything is interstate commerce. Now, the beautiful thing about the Civil Rights Act of 1964 is that Congress really didn't have to stretch too far the meanings of interstate commerce. By targeting public accommodations, these are accommodations that are almost a necessity for travel. Restaurants, hotels, beaches, parks, all of these things are like necessity of travel. And if we think of in our own minds that anytime we go on vacation or simply go to another state or go really more than 50 miles from our house and stay gone for more than a single day, we've engaged in an interstate commerce fashion. And so the Civil Rights Act prohibits discrimination in these areas on the crux of interstate commerce, making the argument very explicitly that discrimination in these areas creates a significant burden on African Americans to travel freely, and the right to travel is a right that we retain in the Constitution, and therefore Congress is defending that right through the Civil Rights Act of 1964. Where this really gets tested is in a case called Heart of Atlanta Motel in 1964. Heart of Atlanta Motel is the first case that really sort of tests the boundaries of the Civil Rights Act. So what was the Heart of Atlanta Motel? At the time, the Heart of Atlanta Motel was a large motel located really at the intersection of numerous interstate highways that discriminated against African Americans in terms of who it would sell to. The United States brought suit against the Heart of Atlanta Motel, and the owner defended himself in a number of ways, none of which were in any way exceedingly robust. So the issue in this case is, in essence, is the Civil Rights Act of 1964 unconstitutional on the basis of its Commerce Clause ties? And the answer the court gives is no, absolutely not. It's not unconstitutional. It absolutely can reach this far. Interstate commerce here is so clear as to make it obvious. But the defense is from the store owner is one that, or one from the motel owner is one that you should be partially familiar of. First off, the argument is that we're not engaged in interstate commerce, and therefore the act can't reach us, which seems odd for a motel to argue, a motel that was literally at the intersection of numerous interstates. But the owner goes on further to argue that it violates his Fifth Amendment rights to choose to basically choose his own customers, and therefore it deprived him of his due process without law, which is hilarious. But also goes to this is where racists always go wrong, and this is the if you want to be racist in the future, don't use the 13th Amendment as a defendant or as something to defend your actions. Because the owner in this case says, well, by the United States forcing him to rent rooms to African Americans, the United States is violating the 13th Amendment because they are putting him in a position of involuntary servitude. If you ever need to defend your actions by saying someone else is making me a slave, you're doing a bad thing. And you should probably rethink all of your life choices, which I doubt the owner of the establishment in this case ever had the sort of self-reflection that one should have. The court here is unanimous, as should not be shocking. They weigh in the ways that it is the court is likely to do, and basically says that hotels, motels, especially particularly in this case, are really the vehicles of interstate commerce. If an individual was taking a trip across numerous states, the ability to get a hotel room is a necessity for that. Ability to eat dinner, restaurants is a necessity for that. And therefore the questions in this case do not seem robust, and it very clearly is a power of Congress to regulate in these areas because there is a close connection with commerce. In fact, it's inextricable, the connection with Congress, especially within the hotels. And so the Supreme Court upholds the Civil Rights Act of 1964, and then the Civil Rights Act of 1964 has went on to desegregate numerous public accommodations and really reach in and allow Congress to regulate commerce in a much more significant and robust fashion, this time for at least a noble cause of ending segregation in these areas.